4 bills are on it. I see Mr. Benton in the audience. And Mr. Benton, you're here on House Bill 51. We'll call House Bill 51 at this time. If you want to come forward, Mr. Benton, and please have a seat, and we'll let you present your bill.
Thank you, Mr. Chairman, members of the committee. I appreciate being allowed to come in here today. House Bill 51, and I'm working from LC 296402S.
That's correct.
This bill came about because of a situation that exists in the state whereby a person that buys a property at a tax sale and that property is part of a homeowners association. The person that buys that property at the courthouse steps does not take full title to the property for 1 full year, but is subject to homeowners association dues during that period of time. And if the property is redeemed, that person has no way of recouping those homeowners association dues. The bill would allow for not only the money that the person has paid for the property, but also the homeowners association dues if the property is redeemed, plus 20%. And I feel like that this is needed to help protect investors that are buying these properties. Be glad to answer any questions, Mr. Chairman.
All right, questions from members of the committee of Mr. Benton. I think what you're looking at on page 2 of your bill, really starting mostly with paragraph C at 36. So if sales occurring after July 1st of this year, there shall be added to the sum of the amount of redemption, whatever has been paid by that owner of the tax deed, the amount that he or she may have paid for dues to a homeowners association, which these are mandatory dues.
Right.
In addition to the payment of the dues, that would also be considered like the tax, would have the 20% added to it as the penalty amount.
Mm-hmm.
Plus interest, correct?
It doesn't say interest. I'm assuming the 20% would be in lieu of interest.
All right. Questions of any members of the committee? If so, thank you. We do have one that
Senator Stone had a bill, something in relation to condominium. Is it the similar bill?
This is the bill that passed the House last year and got all the way into the Senate and got stuck there the last week of the session. This bill passed the House almost unanimously last year.
Nothing further of the presenter. We appreciate your comments, Mr. Benton. Does anyone else wish to speak on House Bill 51? If there's no one else wishing to address the committee, we will close off further public comment. The bill is now in the breast of the committee. Do we have a motion?
Due pass.
Motion is due pass. Seconded? And seconded. Any discussion on the motion? The chair will call vote on the motion. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you, Mr. Benton. Next bill we have is going to be, is Ms. Lunsden here? There you are. Come on up front. Sorry, didn't see you over there. House Bill 99. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. Bring to you House Bill 99. It's a bill that addresses a procedure for tenancy in common when a marriage is annulled or a divorce occurs. This issue was brought to my attention by a local attorney who had ran into this situation on several occasions. Primarily what this bill does is to create a default of tenancy in common when there is joint tenancy with right of survivorship, and that issue has not been dealt with through the process of the divorce or the annulment.
And I think this occurs from time to time when people are pro se.
It occurs pro se, and it also occurs with out-of-state divorces at times.
All right. And I think that does present sometimes aftermath problems trying to resolve property ownership and disputes. Questions of the presenter? Doesn't seem to be anyone concerned. Must be a good bill, Ms. Lumsden. You're a subcommittee. That's it. Okay.
I got grilled fairly well yesterday.
Okay.
On the subcommittee, so we're good. But you explained it. You explained it.
It helps to have a good lawyer explain things. All right. Is there anyone who would like in the audience to address the committee on House Bill 99? If not, we'll close all further public comment, and the bill is now in the breast of the committee. Do we have a motion? Motions do pass. And we have a second to the motion. Any discussion on the motion? Not, the chair will call the question. All in favor of the motion signify by saying aye. Opposed, like sign. Motion carries.
Thank you, sir.
Got your bill. Next we have is, I believe, House Bill 197. Mr. Jacobs is not here. I think I can address Ms. Beskin. You got a bill. I'm going to pull yours up next, and then we'll wait and see if Mr. Jacobs comes in. So we'll have Ms. Beskin's bill, House Bill 207, and we'll let you say that you push your button for me. There you are.
Okay.
And we'll let you present your House Bill 207.
Thank you, Mr. Chairman and members of the committee. I have today House Bill 207, which deals with disqualification of judges, judicial officers, trial jurors, and grand jurors in the case of relationship or consanguinity within the 6th degree. Currently, the law provides that if, for example, a trial juror is related to a party who has an interest in the case within the 6th degree, that person is disqualified from serving. And this revision would change it to disqualification if the relationship is within the 3rd degree. So first I want to talk about what 3rd degree is, and then I'm going to talk about why this is important or necessary. You're related in the 3rd degree to people who are your parents, your grandparents, your great-grandparents, your children, your grandchildren, your great-grandchildren, your brother, your sister, your aunt, your uncle, your niece, your nephew. This would say that you would automatically be disqualified from serving as a judge or a juror in case of that relationship. Why is this important? It's interesting because Georgia by statute has provided for disqualification within the 6th degree since 1935. The problem is a lot of judges didn't know that. And the reason they didn't know that is because between 1972 and 2011, the Code of Judicial Conduct provided for disqualification within the 3rd degree. And that doesn't apply to the cases of judges, to jurors or grand jurors, but there was an assumption, and in fact a lot of judges operated under that policy of automatic disqualification within the 3rd degree. In 2011, the Code of Judicial Conduct was revised to provide for disqualification within the 6th degree, since that complied with the statute, but there was a lot of resistance to that from the judges, and I would say the impetus for this change came from the Judicial Council, but once Legislative Council started looking at it, realized we needed to change 3 parts of the code to make it all consistent. So I would also point out that this is consistent with the ABA Model Code of Judicial Conduct, as well as the Codes of Judicial Conduct in surrounding states. Most surrounding states have the 3rd degree provision, including South Carolina, North Carolina, Florida, Tennessee. This would make us consistent, and I propose that we make this change to disqualify in the case of 3rd degree instead of 6th degree.
Well, thank you for that good explanation, Ms. Beskin. Questions? I believe we have Mr. Weldon.
Yes, thank you, Mr. Chairman. Ms. Beskin, I wasn't privy to the subcommittee discussion on this, and I was just wondering if you could give me some history on the selection of 6th degree that was originally enacted by the legislature.
On the history of 6th degree as opposed to 3rd degree?
Yes.
By statute in 1935, we established disqualification for six degrees, and that really had been in the statute all along. But courts were not routinely operating consistent with that. So the statute has been 6 degrees, but that's not consistent with how our courts have operated in many cases, and it's not consistent with prevailing attitudes or surrounding states. And it doesn't mean that judges, jurors could be disqualified for cause if they have an interest in the case or a relationship with a party in the case. It doesn't mean that when you go to have a trial that a person would be prevented from serving as a juror if in fact he or she had a close relationship with a party and interest in the case. It just provides automatic disqualification in cases of 3rd degree rather than 6th degree. 6 degrees are your second cousins or your first cousins twice removed. Most people have no idea who those people are, and yet our statute as currently in effect would provide that those people were disqualified from serving, and if in fact they did serve and it were determined later that they were disqualified, it doesn't mean they didn't sit, but it could be reversible error in a case. So for purposes of judicial economy, we need to clean this up, have a smaller pool of people who are automatically disqualified, and then still leave open to judicial discretion, excusing others for close affinity or relationship.
If I may.
Please.
Well, I'm looking at the table of consequences that you provided to us, and I guess the 6th. I'm not positive how to read this table, but it says where it says person deceased on the left column.
Right.
At the very top.
Right.
If you go over to the 3rd column over, it says 6, and it says second cousins. Is 6 the second degree of consanguinity?
No. Number 6 means that's the 6th degree of consanguinity. The way this chart works is put yourself in the top left column and we're all still alive, so we're not deceased. So this is kind of for purposes of estate administration of estates. But say you're trying to figure out how you're related to your second cousins. You step first to your parents, then to your then to your grandparents, then to your great-grandparents, then down to their child, to their grandchild, to their great-grandchild. That person is your second cousin, but it took you 6 steps to get there. 1, 2, 3, up, down, 4, 5, 6. However many steps it took you to get to a person is the degree of consanguinity. So you're related in the 6th degree to your second cousins.
So under the statute where it's written now, my second cousin would be precluded.
You would be precluded from serving on a jury if the defendant, for example, or if the plaintiff were your second cousin, and in fact many of us don't know our second cousins. If you did know your second cousin and had a close relationship with that person, you would probably be challenged for cause in that case and not allowed to serve on that jury.
So now, and if we enact the law or the bill that you've got here, it'd be the 3rd degree of consanguinity. So if we go from where it says person deceased, the parents, the grandparents, and then my uncle would be, and my aunts would be precluded from serving on a jury if I was on trial.
Correct. They would be automatically disqualified. Anyone else could be removed from service because of a close relationship or affinity, but they just would not be automatically disqualified.
Okay. Well, I can just run this if I may.
Sure.
This other scenario. Okay. So if my great uncle, a great aunt, or my first cousins once removed, they wouldn't be precluded from serving on the jury if I was accused of a crime or civil jury.
They would not be disqualified. They would not be disqualified. But if you had attorneys who had done their voir dire and investigation properly, they would realize that you, in fact, had someone in the jury pool who was your great aunt or uncle, and they would ask questions about, do they know you? Do you spend every Christmas together? That kind of thing. And if the answer to that was yes, they would probably object, and they would be challenged for cause.
Yes, sir.
Now, were you able to discuss these issues with the Public Understanding Council?
For that, I would request, I have Ms. Catherine Fitch here from the Judicial Council, which was the impetus for this change, but I believe she has also spoken with other bar associations. So can we recognize Ms. Catherine Fitch?
Well, we will in a minute when he's through asking questions. Are you through questions of
Okay.
Ms. Beskin?
If you want to defer to Ms. Finch,
We will in a minute.
If I could just ask a couple more. And where I live, there's lots of folks that not only do they know the great grandparents, but they're pretty close with them. But we have the Public Defender Standards Council, and they do probably 85% of the cases in the circuit. And those lawyers that are loaded up at the Public Defender Standards Council, they wouldn't, if they got down to this in all the cases they try and they deal with.
You would find enough people in the jury.
Yes, right.
That's right.
We would. We sure would.
Well,
That's
I agree, and this will be disqualifying fewer people. Ideally, every public defender would have unlimited amounts of time to question jurors, but that's just not the way it works. This disqualifies fewer people. The risk is if you have a trial and one of your jurors was disqualified, it's reversible error. Can be if it's brought
Isn't
up.
it true nationally the standard is recognized to be the third degree?
That's
pretty much?
that's what I would say is the standard. It's in the
Yeah, there was
model
research
codes.
on it. Ms. Fitch will be able to talk to that when she addresses us. We'd like to hear from Ms. Fitch at this time.
Yes.
Ms. Fitch, why don't you come forward, please, and identify yourself and
Hi, I'm
with whom you're
Catherine
associated.
Fitch with the Administrative Office of the Court's Judicial Council, and this came to us from the Supreme Court. As y'all probably know, we have a new Code of Judicial Conduct that is going to come out hopefully in April, and so this puts us back to what we had previously before 2011. This is part of a study committee trying to bring us in line with national practice and the practice that we had for about 40 years. And that committee was chaired by Justice Thompson, Robert Ingram, Lester Tate served on that, Judge Dillard, and a bunch of other fine folks, and they all agree that the policy of the surrounding states and the ABA and what we had for 40 years is the proper balance between efficiency and fairness, and we only changed it in the code in 2011 because someone discovered the 1935 statute, and no one has any idea why it was put in at 6th degree back in 1935.
So you did do your review of the other adjoining states, and the ABA has
Yes, in fact, you all
model-
should have in your folders the ABA model code and
that's
information.
this sheet here.
Yes, and you'll notice only Alabama has the 4th degree,
Fourth degree.
but all of our other surrounding
You can
states.
find a jury over in all Alabama.
Unrelated, yeah, that's right.
I wasn't going to make that joke.
And what we're hoping is, we're trying to clear up that tension between, we want our Code of Judicial Conduct to agree with statute.
Right. And it's true in rural areas, if they were to apply this, it'd be much harder a lot of times to get a full panel of jurors to sit and be selected from, right?
Yes, and of course our judges know that, if there is a conflict in a close family relationship, they are under a duty to disclose that.
All right. Any questions of Ms. Fitch? None? We thank you. Anyone else wish to address the committee on House Bill 207? If not, we will close off further public comment. The bill is now in the breast of the committee. Do we have a motion? Motion to pass. Any discussion? Prior to vote on the motion, further discussion, the chair will call the question. All in favor of House Bill 207 signify by saying aye. Opposed, like sign. Motion carries. Thank you, Ms. Beskin. She carried that at the behest of the chair, and I appreciate it. We are now down to House Bill 197, so rather than holding up the committee, let me give you some background. This is a bill that is compiled of really three provisions dealing with the Uniform Code Commission recommendations, and the one that I'll speak of as being the portion that we had the debate about was the one of the foreign country money judgment section, and that I believe starts with this is Jacob's bill, but I did have an opportunity to listened to the debate about it, and one of the concerns we have to be addressed. I'm looking at the sections. I'm sorry I don't have them all in my mind. It is Uniform Foreign Country Part 2, Money Judgment Recognition Act. And one of the things we're addressing here, as much as we have the use of the foreign judgment provision is uniform law, and that means recognizing the judgments of sister states, where you have, say, in South Carolina, a judgment entered, that judgment's brought over to Georgia and perfected for filing here. There's a statutory proceeding to be followed. This section is to set out using the Uniform Code provisions adopted by the Commission, the Uniform Code Commission, for the foreign country type judgments. Now, one of the things we had a concern about was the uniform statute provision addressed a 15-year statute of limitation. That is not what we currently have in Georgia as far as the statute of limitation applicable to what we refer to as foreign money judgments. It is a 5-year statute of limitation. So after our discussion, it was determined that that's probably the best thing to leave alone and not have a separate provision addressing the statute as it applies to foreign country judgments being different from what we have for just regular foreign judgments. So by removing that provision of the 15 years, it automatically reverts to what we have now as any other judgment, which is a 5-year, and you of course have the right of renewal of that judgment for I think 2 times, if I remember correctly. It's been a long time since I addressed that section of law, but that is the general law provision. So that is the change that was made in that section. This otherwise follows pretty much the premise of the Uniform Code in that area. Ms. Travis, you were familiar. What was the other 2 sections dealing with as far as Uniform Code sections?
On page 6, the code section that used to be labeled 9-12-118 was the one that was removed, and then 119 and 120 got relabeled as 118 and 119, and that was to take off the 15 years. And the only other change was on page 45 at line 1503. The word voidable was put in before the word transfer.
Yeah. The other thing we're doing is updating the UCC, again based upon the provisions adopted by the Uniform Code Commission on UCC, which has been adopted by I think all the states but 3 currently nationally. So we're one of the last of the states to adopt this, but it's to bring up to current practice and terms that are used on the Uniform Commercial Code, which is Title 11. Mr. Weldon, do you have a question?
Yes, Mr. Chairman. On page 3, the it's 9, I guess what will be the new 9-12-112, says that this applies to money judgments and where there's a final and conclusive and enforceable judgment. And in subsection B on, I guess, line 81, it says that this article does not apply to a judgment for divorce, support, or maintenance, or any other judgment rendered in connection with domestic relations. What's the policy? What's the policy behind not enforcing foreign judgment?
I think we have other provisions in law, do we not, under the section 19, is it?
Title 19.
Title 19, excuse me, that addresses foreign country judgments dealing with divorce, alimony, and child support. So that's why we accepted it in this area. Further questions? But following up, I was saying that you have the provision about the foreign country money judgments. you have the UCC, and then you have one other very small area, that is the last section, which is Part 4B, which dealt with what we call uniform voidable transactions, and we stopped using the term fraudulent transfers and are using the term voidable transactions as a correct term of art for these type of proceedings. That's the only change made there. That's on page 45. So that's the three areas of law this bill touches on. And so we had a subcommittee, pretty good discussion subcommittee about it, and it was passed through with approval. Anyone else wish to address the committee on House Bill 197? If not, we'll close off further comment. Chair will entertain a motion from the committee to pass. Seconded. Any further discussion on the motion? There be no further discussion. Chair will call the question. All in favor of the motion signify by saying aye. Opposed, like sign. Very good. We've got our judge with us today. I forgot to mention our judges over here. Judge Hamrick, former state senator from down the Noonan Way. And who's the lovely lady with you? Judge Johnson. From Gainesville. That's right. Glad to have you today with us too, Judge Johnson. And we had another judge in here, but he pulled out. Judge Ellington was here from the state court. He just couldn't stand discussion about law. Do we have anything else to come before the committee? We'll stand adjourned. Thank you.